My name is Ruth and I am an Australian registered migration agent and a solicitor or lawyer of the Supreme Court and High Court of Australia. In this video, I will be sharing with you on the updates on subclass 491 visa. Now, prior to this video, I have also posted another video with more detailed information on the subclass 491 visa, and you're welcome to watch the previous video on the link below. Now, I note that the information in this video is not to be treated as legal advice, but it will provide you with vital information concerning this program. In November 16, 2019, two new regional visas will be introduced. They're both provisional. One of them is called the subclass 491 skilled visa, and the other one is subclass 494 visa, which requires an employer to sponsor you. The subclass 491 visa will be replacing the subclass 489 visa. In regard to time frame, the 10th of September 2019 was the last day to issue an invitation on expression of interest made. 15th of November 2019 is the last day for any invited applicant to lodge their visa, and that is in relation to subclass 489. Now, from the 16th of November 2019 onwards, it will be the start date of expression of interest for subclass 491. So that's very, very exciting for our clients who may be eligible for subclass 491. 16th of November 2022 will be the introduction of subclass 191, which is a permanent residency application for subclass 491 visa holders. Now, as I discussed on my previous video, if you would like to get permanent residency under the subclass 491 category, then you will need to be on that visa for 3 years and work in a regional area for at least 3 years, after which you can transition into permanent residency subclass 191. Okay, now in order to be eligible for a subclass 491 visa, an applicant must be either nominated by a state or territory government agency, or if you're sponsored by an eligible family member residing in a designated regional area. And that's of course if the occupation list allow your family member to sponsor you. So you need to double check that. Designated area, the definition of the designated area is that it can be anywhere in Australia except for Sydney, Brisbane, Gold Coast, Melbourne and Perth. So if you are nominated by a state or territory or are sponsored by a family member anywhere outside the places that I have just mentioned, then you may be eligible for this visa. If granted, the visa will be valid for 5 years, and that's fantastic because that gives you time to look for employment and to settle. And as long as in that 3 years time, 3 years within the 5 years, you've met the minimum requirement, you can transition into subclass 191 visa. An applicant may be inside or out of Australia to lodge the application. A visa applicant must be invited to apply for this visa by the Department of Home Affairs Australia. And at the time of invitation, the applicant must be under 45 years old. Now, an applicant will also need to nominate a skilled occupation on a relevant list and meet skills assessment requirement. So skill assessment really is really important. If you have not already done that, then we would definitely advise you to proceed forward with skill assessment, because without that, you can't really go forward. Our firm actually, we assist our clients with skill assessment applications. So if you feel that it's quite difficult and you're not really understanding the procedure, please feel free to shoot us an email and we'll be happy to assist you through that process as well. With the new changes floor, there are changes in points claimable, which is really exciting. For example, you will have more points for having a skilled spouse or de facto partner. So generally they have to meet the skill requirement on a relevant occupation list and also the English requirement. And if they do, you get extra 10 points, and that's a lot. You are also eligible for more points if you're nominated by a state or territory government, or if you're sponsored by a family member residing in regional Australia, and that's 15 points. So previously for the 489 visa, it was just 10 points for that, but now with the 491 visa, they've upped it with 5 points, so now it's 15 points. So that's fantastic. Plus, if you have got a qualification, they call it the STEM, S-T-E-M qualification, and that's if you've got a qualification which is relevant to science, technology, engineering, and mathematics, potentially you can get another 10 points, and that's fantastic. And if you do not have a spouse and you do not have a de facto partner, so if you're single, you potentially will get another 10 points. So that's very exciting for our single applicants. And also if your spouse or de facto partner has competent English but they don't meet the skill requirement, but they have sat for an English test or they meet competent English requirement, then you can get additional 5 points. So those are the new points test that is applicable. The good news is single applicants will not be disadvantaged, as they will be ranked equally to those applicants with partners' skills. The ranking system will be as follows. Number 1, applicants with a skilled spouse or de facto partner. And equal to the first priority is applicants with no spouse or de facto partner. The second priority is applicants with a spouse or de facto partner who meets competent English but not the skill requirement. Third priority will be for applicants with a partner who does not meet competent English or skill requirement. Okay? The subclass 491 will have 2 mandatory conditions. Number 1 is called condition 8578, and that is to notify immigration of any changes within 14 days of the change occurring. So that can relate to your residential address, to your email address, to your phone number, to your passport details, to your employer's address, or the address of your location. So you need to notify immigration of those changes. And the second one is called condition 8579, and that is whilst the visa holder is in Australia, you must live, work and study only in a designated regional area and not outside. If you do not meet those requirements, then potentially the visa may be cancelled by the Department of Home Affairs. So always abide by the condition of your visa. Now, please note that the information in this video is general information only. Do not treat this as legal advice because each case is different and we treat each case on a case-by-case basis. With the ever-changing laws of immigration, it is vital that you obtain updated advice that suits your situation. If you're a skilled applicant and you require advice on how to proceed with your case, please do not hesitate to contact us on the email address below, and I would be happy to assist you. Thank you and all the very best.